When the Supreme Court rules on Wolford v. Lopez in June, the decision could potentially trigger legal challenges to concealed carry restrictions in 15 states that have similar laws. This isn't speculation. This is analysis based on the legal structure of these state laws and how they'll intersect with whatever standard the Supreme Court applies to Wolford. If the Supreme Court rules that Hawaii's default ban on carrying on private property open to the public violates the Second Amendment, that ruling will create legal precedent. Immediately, gun rights organizations like the Second Amendment Foundation, the National Rifle Association, and the Firearms Policy Coalition will use that precedent to challenge similar laws in other states. The states with laws most vulnerable to challenge are California, New York, New Jersey, Maryland, and Delaware. These states have concealed carry restrictions that operate on different frameworks than Hawaii, but they share the same core principle. They presumptively restrict where carrying is allowed unless specific conditions are met. California requires demonstrated need. New York requires demonstrated need. New Jersey has similar requirements. Maryland has restricted carry zones. Delaware has restricted zones. If the Supreme Court says that Hawaii's presumptive ban on private property violates the Second Amendment because there's no historical precedent for such bans, that reasoning could apply to California's need requirement. If the court says states can't restrict carrying without historical evidence, California's entire permitting framework becomes vulnerable. Same for New York, New Jersey, Maryland, and Delaware. Their entire permitting structures could be struck down. But the Wolford decision could potentially affect more than just these 5 states. Any state that has magazine bans, any state that has assault weapon bans, any state that has restricted carry zones could face legal challenges based on the reasoning the Supreme Court uses in Wolford. The decision will establish principles about how strictly courts should apply the Bruin framework. If the court applies it strictly, saying there must be very close historical analogs for any regulation, then dozens of state laws become vulnerable. Illinois has an assault weapons ban that could be challenged. Connecticut has magazine bans that could be challenged. Washington has magazine bans that could be challenged. California has magazine bans that could be challenged. Massachusetts has magazine bans that could be challenged. New York has magazine bans that could be challenged. And several other states have similar restrictions. That's at least 15 states with potentially vulnerable firearms regulations. The mechanics of how this happens are important. Gun rights organizations will file lawsuits in federal court immediately after the Wolford decision comes down. They'll argue that if Hawaii's law is unconstitutional under the reasoning in Wolford, then these other state laws are unconstitutional for similar reasons. Federal judges will have to follow Supreme Court precedent. So many of these cases will succeed at the district court level. States will appeal. Some cases will be appealed to circuit courts. Some might even reach the Supreme Court again if the issues are novel or if circuit courts split on how to apply Wolford. This creates a domino effect. One Supreme Court decision in June could unleash dozens of legal challenges across the country. Gun laws that seemed settled could suddenly become vulnerable. States that thought their restrictions were constitutionally sound could find themselves defending those restrictions in federal court, with their lawyers arguing from increasingly weak ground. But here's the other side of this analysis. If the Supreme Court rules narrowly in Wolford, saying only that Hawaii's law is problematic as applied to private property open to the public, but doesn't strike down Hawaii's law entirely, then the domino effect might be limited. The court might distinguish Wolford from other state laws and find ways to uphold them. What legal analysts predict is somewhere in the middle. The Supreme Court will probably strike down or substantially narrow Hawaii's default ban. The court will probably say states can't operate on the presumption that carrying is prohibited unless the owner consents. But the court might also leave room for states to regulate carrying in specific places like government buildings, courthouses, or schools. If that's the outcome, then states like California, New York, and New Jersey will face immediate legal challenges to their concealed carry permit schemes. They'll have to defend their systems in federal court. Some will likely lose. Others might win by demonstrating historical precedent, but the litigation will be massive. 15 states with various gun restrictions are essentially waiting for the Wolford decision to see which of their laws become vulnerable. State attorneys general are preparing briefs. Gun rights organizations are preparing legal challenges. Federal judges are preparing for an influx of Second Amendment cases. The timeline matters too. If the Supreme Court decides Wolford by the end of June, legal challenges will be filed by August. Preliminary injunctions could be sought. By the end of 2026, we could see initial rulings in dozens of cases. By 2027, appellate decisions could start coming down. By 2028, some cases might reach the Supreme Court again if the lower courts split on how to apply Wolford. This creates uncertainty for gun owners in these states. If you live in California, New York, New Jersey, Maryland, Delaware, Illinois, Connecticut, Washington, Massachusetts, or any other state with restrictive gun laws, you need to understand that those laws are potentially vulnerable to legal challenges based on the Wolford decision. The practical consequence is that you might gain gun rights you don't have today. A California resident restricted to concealed carry might gain the right to carry openly if California's permitting scheme is struck down as unconstitutional. A New York resident who can't get a permit might gain the right to carry if New York's system is struck down. But during the litigation, there's massive legal uncertainty. Gun owners won't know for months or years whether their actions are legal. That uncertainty creates risk. The Supreme Court's Wolford decision in June is not just about Hawaii, it's potentially about reshaping gun carry rights across 15 states and beyond. That's why every gun owner should be paying attention to this case.